Welcome, everybody. This is Financial Speaking with Jason LaBarge. Hope everybody had a great Thanksgiving and looking forward to a great holiday season. I know we are here at LaBarge Financial. Today, we have a special guest. We have Kaitlyn Johnson from Liberty Legacy Law Group, and we're going to talk a lot about estate planning today. At LaBarge Financial, we always like to say we're a one-stop shop. We'd like to not only look at investments, but also your estate, your tax planning, because I always say what might be good for the portfolio may not be good for the estate. What might be good for the estate may not be good for the tax return. And so we want to make sure we're quarterbacking all of that. And so we're going to do a deep dive today with Kaitlyn on estate planning. And so if you would first, Kaitlyn, just tell us a little bit about yourself.
Sure. Thanks, Jason. So happy to be here. Thanks for having me.
No problem.
So yes, I'm Kaitlyn Johnson. I'm the managing partner at Liberty Legacy Law Group, and we are an estate planning and elder law firm. So we do everything from wills, power of attorneys, advanced medical directives, trust, to guardianships, and then, estate administration, trust administration, and deeds. We do deeds. So people adding or removing somebody from a title to their deed or a life estate deed, things of that nature.
I think that was my first interest in you and your partner was the deed conversation. We have so many clients, even going back years, that started with asking if they should add their children to the deed to their house. And obviously that's a big no-no. But talk a little bit more about why making sure the deed to the house is appropriate.
Sure. So that's, I actually started the deed part of our law firm about 6 years ago. So I saw there was a big need in the community revolving around deeds. So I worked in the title industry for a while where people, bought and sold their properties, handled the settlements, the closings, things like that. And a lot of people had a lot of questions about deeds. And I would see a lot of people come through where they would, say, hey, I want to add my son to the deed to our home so that when we pass away, the home goes right to my son and avoids probate. And you're right, that's a big no-no. So a lot of people will do that with the goal of avoiding court, but what they don't realize is they're causing a lot of tax implications
problem,
and a lot of liability issues. Because if you add your son to the title to your home, now your son's liabilities are your liabilities because it's his house too. So if he gets sued or goes through a divorce, your house could be subject to his liabilities. And then also adding your child to the deed to your home would cause them to not receive the step up in tax basis with the capital gains when you pass away.
Step up in basis is such a valuable piece of overall estate planning. The fact that, a lot of our clients, they bought their home or built their home 30 and 40 years ago for $100,000 or $50,000 even. And, they'll sell it today for, $1.5 million or. And so getting that step up in basis where if you add your son or daughter to that deed, they didn't pass away, right? So they don't, and if they're named on that deed, they don't get the step up in basis. Now, if they're added as a 50% owner, whatever, there's a lot of scenarios that we can do that, but that is a big no. And that is what really drew me to your firm, the fact that that was a big focus of what you guys did. And I think the second thing that drew me to you guys was your background. And you don't have to name, firm names or anything like that, but tell us a little bit about you and your partners. Or first mention who your partner is, and then talk about your guys' background.
Yeah, so my law partner is Melissa Patty, and she has been my lifelong best friend since I was 3 years old.
That's amazing.
It's crazy. She's I tell everybody she's stuck with me. She can't get rid of me since we were 3 years old. It's cute. We used to, build forts we had woods in the back of our homes. That's how we were friends. We were next door neighbors, and we went from building forts to building a law firm together. So it's pretty cool. But Melissa and I come from different backgrounds. She, we both ended up going to law school together. So we have like our preschool graduation picture up to our law school graduation picture together.
That's really something.
Yeah. But she went out of law school and started working in a personal injury law firm. She had to work in a personal injury firm during law school too. But she just realized for her that wasn't very fulfilling. She just didn't really like that area of law. It kind of felt more like a pipeline of clients rather than really getting to spend time and connecting. So that's when she left the personal injury side of law and went into estate planning. And she ended up at a firm that's also around here that was small at the time but grew over time. Me myself, I more so was into real estate. So I was working at a real estate law firm before law school and working in real estate during law school and also doing estate planning during both. And then after law school, I focused primarily more on real estate. And I think that was a natural progression for me to venture into estate planning even more exclusively because you build all these assets, right? And now you need to protect them and make sure that they're going to transfer upon your death the way you want them to, or be managed if you're incapacitated, the way you want them to. So that's kind of how I ended up in estate planning. And so, I started my company doing deeds quite a few years back, and concurrently while doing that, I started working at the same estate planning law firm as Melissa.
Got it.
So Melissa, she was managing partner of the firm, more so handling like operations and things like that.
Okay.
It was a very large firm. It was about 60 to 70 people. And for her, it's great. Big law firms are good. Definitely they can have a big support staff. They definitely have their pros. But for her, she started managing more attorneys. She was managing, I think, about 20 attorneys underneath of her and not really getting to spend time with actually meeting clients anymore. And, that was the fulfilling part of law for her and her practice, is actually being able to meet families, help them spend time with them, get to know them. And so she was doing that. I was working in their Annapolis branch. She was in their headquarters in Towson. And so we were working together for a few years, and then we both kind of sat down one day and we're really just trying to figure out where we wanted our lives to go, what direction we wanted. And, we both knew that we weren't very happy where we were. Nothing negative about where we were. It's just we felt like the firm kind of outgrew us. You know what I mean? And we both thought about when we were really happy, and it's when we were both working for smaller firms. And so that's when we decided to start our own law firm together, to be kind of, a small to mid-sized law firm, never get too big, because it was really important to us to really spend quality time with clients and really get to know them and, slow down and spend time.
Well, I think there's there's something to be said about, managing people versus managing actual clients, right? I love working with clients as well. But as a business owner, you naturally have to manage people. And I'm with you. I love development. I love seeing the impact that what we do, what that impact has on our employees, because it's different than what it has on, end clients. So it's unique and it's different, but I definitely can understand the challenges and the yearning for wanting to, because people even ask that of me, like, how long, Jason, are you going to continue to work directly with clients? I'm like, what do you mean? Like, well, Jason, you could hire other financial advisors. And, my favorite part of my day is working directly with the folks we serve. And so I get that. And you guys have had a lot of success, since starting it. And that's been primarily estate planning, deeds. Let's say that you get 10 clients. This is what I really wanted to dive into today. or 50 clients, whatever the number is. What percentage of those clients would you say require a trust?
Actually require a trust? I'd say let's say out of 100, easier math. I went to law school for words, not numbers, Jason. Okay. So out of 100, I'd say probably actually need a trust. Maybe 25%, 75%, I'd say do not.
I totally agree with that assessment. But why do you think that the 100 people that walk in there think that they need one? Why do people, and maybe not all 100 think that they do, but a large number will come in and even ask me, should I get one? And why do you think that is? Is it marketing? What do you think that is?
I think marketing definitely plays a big role in it.
Why the fear for probate? Everybody, and again, obviously I'm not suggesting everybody go through probate, but like probate is this like boogeyman that people are like, oh my God, I'm going to go through probate. I'm like, we help people every day. I mean, it's not like it's the end of the world. We want to avoid it, obviously, but this push in the last 5 to 10 years on trust, I don't get it.
Yeah. I think, avoiding probate, I will say probate isn't fun. It is better to avoid probate. But the thing is that you can avoid probate without a trust,
Super easy.
right?
Yes.
You can have
Yes.
beneficiary designations on your
Yes.
assets. A lot of people don't realize you can have a beneficiary on your car,
Totally.
you know,
Your bank accounts.
yeah, and bank
And
accounts,
if
you
by
can
having a
have
beneficiary, you
beneficiaries.
bypass probate.
Right.
And
And then a
again,
life estate deed for the
for the
house.
house. And I don't
Yeah.
mean to sit here and say that probate is easy or probate's fun. Obviously, it's not.
Yeah.
But this need for trust, I think, is, and again, there are situations where trusts are absolutely appropriate. We could come up with several examples of when that is. But gosh, I think for the most part, people don't need them. Like you have your beneficiary designations, you have your life estate deeds, and then everything else is conversation. Like, hey, do you want to have the couch? Do you want to have the jewelry? Like,
Yeah. I think you're right. I think it has a lot to do with marketing. A lot of things, we're in a very high tech world now where everything's on the internet. And you see a lot of like reels on Instagram or TikTok, saying get a trust. And I think people just hear it over and over and over and they think,
Sure.
okay, I
gotta
got to
get
get
a
a trust. And then their friends get them. And then because their friend has them, they think they need one. But really, a lot of people, I'd say the majority of the reason people are interested in a trust is because they hear it avoids probate. But like I said,
That's
there's
not
other
the
ways
that's
to
not the
avoid
only way to
probate.
do it, right?
Yeah, and even if you had to go through probate, if you have a, will that's set up correctly,
Properly,
it's
right.
done well.
Right.
It's very clear. It doesn't leave a lot of ambiguity or
Right.
vagueness.
Right.
Probate isn't terrible. You know what I
That's
mean?
right. And like, when I really do a deep dive with clients, when you really find out what the driving point is or what the fear is, it's a fear that's really not found in fact. There's no basis to it. It's like
Right.
what happens if my daughter gets divorced? Does the son like? And there's what you know what I mean? Like there's always a fear there that's not necessary. But then there will be. I had some clients in last week, and they kept thinking that it was their potential divorce of their son that was the source of their anxiety. But at the end of the day, it was a fear that he couldn't manage the assets on his own. And that is a scenario where, trust can be appropriate and it should be addressed, because there are definitely situations where a trust is needed. And so that's I think the difficult part of your profession is determining when it's appropriate, when it isn't, because you could go to 10 different attorneys and get 10 different
Right.
suggestions.
Yeah. And I'd say, that's why as soon as a client, like let's say it's a couple, John and Jane, they walk into our office, one of the first things we're asking them when we sit down is, what are your goals? What's really important to you, and really kind of dig into that. And even if they're like, well, I want to avoid probate, digging a little bit further, like, well, why do you want to avoid probate? To really understand, like, why do you think you need to avoid probate? Or really, if you just ask further questions, you actually figure out what the underlying fear is, and then can address it appropriately.
And not every attorney does that. I think we're all so busy. We live in this world of hyper responsibility. I think it boils down to, obviously your assets are so important to you. You want to be hyper vigilant. You want to be hyper responsible. So then you naturally think a trust is going to achieve that for me. And so I think a lot of it's mental, which I always tell clients, nobody ever said financial decisions had to be rational. Nobody said they had to be profitable. We're humans. They don't have to. Nobody ever said they had to. That money can sit in a bank account. I know it's earning less interest than what if we had it invested somewhere. And I get that. Like clients will say, I get it, but I need it here. It makes me feel better. It's a warm blanket, and that's just as valuable as anything else, right? So that nobody said these decisions had to be rational. For me, it gets down to, is it worth the dollars spent required to get it?
Right.
That to me is the bottom line. But and that's gonna be different for everybody.
Yeah.
That's gonna be different for everybody.
Yeah, it is. And that's one thing. I mean, I've been doing this for many years now, and I can say no one family is the same. Everybody has different unique circumstances. But I think you hit a really good point there, that there's a lot of underlying fears. So really the number one goal for me is to figure out what is that underlying fear. And you're right, when it's dealing with your legacy and your assets and your financial assets, there's a lot of emotion in it. A lot of just being comfortable and having that comfortability. And I think what people really want at the end of the day is peace of mind. So if they're told something like a trust is going to give them peace of mind, they're like, that's my answer.
That's it. Okay.
But not necessarily always the case, right? So that's why we have to talk through it.
Let's say out of the 25% of people, that come in that do need a trust, why don't you go through a few examples of when a trust might be appropriate?
Sure. Yeah. So, as we said earlier, there are definitely some circumstances where trust would be appropriate. I'd say, say for instance, you have a blended family
Yeah.
situation, right?
Right.
Where you have children from previous relationships. A lot of people or a lot of couples want it so that, a lot of their assets or all of their assets go to the surviving spouse to make sure that the surviving spouse is taken care of
Yeah.
throughout their life, but they also concurrently want to make sure that their children aren't
Yeah.
disinherited,
Yeah.
whether it be intentional or
Yeah.
unintentional.
Yeah.
So
And I think
that
that's
could,
common. I mean,
yeah,
that's a common problem.
yes, absolutely. A lot of blended families these
Yeah.
days, right?
Yeah.
And so it's making sure that the surviving spouse feels comfortable,
Yeah.
that they're not going to be arguing with, stepchildren, and
Yeah.
making sure your children are comfortable, that they're not going to lose their inheritance, and
Yeah.
that the surviving spouse, stepmother, stepfather is going to leave everything to their children,
Yeah.
things like that. So that's definitely a situation where it might be
Well, and I think
appropriate.
too, along those lines, non-beneficiary driven assets. I'm a book collector. I have a lot of rare books. They mean a lot to me, but I can't list a beneficiary on those,
Right.
right? So if I passed away and my wife remarried at some point and started giving those books to kids they had after that, or step kids that would be as of children of her next husband,
Right.
if that makes sense, I would roll over in my grave.
Right.
Um,
'Cause
if
it's sentimental.
those books, yeah, so I think it's situations like that too. Jewelry, excuse me. There's a lot of scenarios. What other examples can you think of? You certainly spendthrift.
Yep, spendthrift. So say, you have a son who has gone through bankruptcy 2 times already. Are we just going to cross our fingers and hope that he figures it out by the time he passes
Yeah.
away? Or maybe you want to, leave some stipulations
Yeah.
as to how he can receive the money. Maybe, span it out over a period of time, distributions over years, so that it doesn't all, go to them in one lump
Yeah.
sum and then it's all spent. Children with addiction issues, I'd say
Yeah.
that's a big one,
That's very common.
where you want to leave to that child who maybe currently has an addiction issue or did in the past, and you worry that, especially if they did in the past, that you pass away, now they're going to be grieving, and they just inherited a lot of money, that could,
That's
kick
very
in their
real.
addiction
Yeah, that's very
again.
real.
So making sure that they can still receive the assets, but it's protected, maybe put somebody else in charge of the
See,
money.
I was just going to ask that though too. Like a lot of the problems I'll see, and this isn't necessarily trust related or whatever, but it's more like you end up sometimes pitting one kid against another, or you have one kid, one child trying to decide what's best for their nieces or nephews, or they're put in a position to decide based on words that you left or that you wrote as the attorney. That's a difficult position too, and that goes
Yeah.
beyond just trust. That's just estate planning in general. But I think the administration part of it is just as important as creating the documents, but implementing them post death, I think, is another huge piece.
Yeah. And a lot of that goes into the estate planning side of it, like really thinking out, like, how is this going to play out in real life? Okay,
Yeah.
so, you're leaving assets to your kids 50-50, and if one of your children pass away before you, their 50% share goes to their children, your grandkids, and you name that respective aunt or uncle to be in charge of that money, right? But those kids are living with the surviving parent.
Right.
And now that money can be used for their health, education, maintenance, and support, but maybe that aunt or uncle isn't the best person to
make
know
those
what that
decisions.
is. You know what I
get it.
mean?
And then you're pitting one against the other.
Right. And that can pose some issues too. So you really have to really talk through
So
all
is that
that.
the executor then? Is that like a professional? Could a potential solution for that to be a professional trustee? Or
You could
right?
have a corporate fiduciary for sure. So somebody who is correct, like a professional, somebody who works at a bank or an advisor of some sort, not a direct family member where you're going
Right.
to cause family conflict. But sometimes it is okay to put the aunt or uncle in charge, or
Right.
sometimes it's okay to put the surviving parent in charge. And that's where it's so different for every family.
Right.
And you really have to dig into those family dynamics.
And that can be so hard. Nobody wants to talk about dying. Nobody wants to talk about potential problems that can result of your son or your daughter not making proper decisions. But not having a plan is planning to fail. And that's something that, as a financial advisor, I think my industry historically kind of felt like that wasn't our responsibility. right? I'm there to man. In fact, I even have clients that'll ask me from time to time if I can be like a decision maker post death, and my answer to that is no.
Right.
The conflict of interest. Now, I'd be there as a advisor for the investments, et cetera, but not as a decision maker. So finding the right person, um, I think, can be very difficult. But at the end of the day, surrounding yourself with professionals that have your best interest at heart, whether they're a decision maker on paper, I
Hmm.
can help influence what a son or a daughter might do in terms of the bigger picture with the investments that they have. That's can kind of be my role,
Right.
working hand in hand with the attorney or with the corporate fiduciary.
Hmm.
So I think that's a kind of my vision for why having the one-stop shop was I think best for my practice and our clients' futures, is that I'm not listed, technically there as a decision maker, but I can certainly help to the best of my ability. But at
Hmm.
the end of the day, I can only advise. The decision is going to be up to whoever the decision maker is.
Yeah.
So having that balance between the right decision maker and the right people around to help influence, I think, is the best a person can do. You can't come up with, some of these clients will see that they're coming up with all these scenarios, and you just can't address every possible scenario. At the end of the
Right.
day, as any good parent knows, all you can do is hope, hey, I did the best I could do. Right?
Right.
I gave my kids the tools. If they want to go blow that on 15 Teslas at the end of the day,
Yeah.
what am I going to do about it?
Exactly.
Like I can't address every possible scenario.
Yeah, and that's what I
It's
tell
tough.
clients. I'm like, I when they're coming up with so many different scenarios,
Yeah. What if they did this? And then what
we
if they,
can't
it's like,
clone
we
ourselves.
can't.
We can't avoid it. If we're going to become incapacitated, we can't avoid death. And if we're not there, or we're not mentally there to make the decisions,
Yeah.
we just have to choose who we think is most capable of making those
Yeah.
decisions, and choose them wisely, and
Yeah.
just make sure you trust them. And if some people will have a hard time choosing somebody that they feel like they can trust to
Yeah.
make those
Or
decisions,
who will
because
be
it's
there.
not them, exactly who will be there. And I just try to emphasize, there's somebody you trust more than the government. I know there's
Yeah.
somebody you
Yeah.
trust
You
more
can
than the
find somebody.
government, but that's why it's
Totally.
important to create kind of your professional team. Like, have your
Yeah.
financial advisor, have your estate planning
Yeah.
attorney, maybe your tax accountant, because you're not just building a team for yourself to help manage and grow your assets while you're alive and protect your assets, but that team's also
Yeah.
going to be there as a resource for your
Totally.
family when your family needs them one
Totally.
day. So,
And that's my vision. I know you share that vision. We want to have a network of professionals that we lean on.
mhm.
Um, Liberty Legacy Law Group.
Yes, tongue twister,
It
I
is a
know.
tongue twister. I'm going to get it though. Liberty Legacy Law Group, and the partner's Melissa.
Yes.
And this is Kaitlyn Johnson. Again, this is Financially Speaking with Jason LaBarge. Again, want to thank Kaitlyn for joining us today. And hopefully you guys had a great Thanksgiving again and a great holiday season. Have a good day. Insurance products are offered through the insurance business LaBarge Financial, LLC. LaBarge Financial, LLC is also an investment advisory practice that offers products and services through AE Wealth Management, LLC, a registered investment advisor. AEWM does not offer insurance products. The insurance products offered by LaBarge Financial, LLC are not subject to investment advisor or broker-dealer requirements. Securities offered only by duly registered individuals through Madison Avenue Securities, LLC, member FINRA SIPC. AEWM and MAS are not affiliated companies of LaBarge Financial. Investing involves risk, including the potential loss of principal. Any references to protection, safety, or lifetime income generally refer to fixed insurance products, never securities or investments. Insurance guarantees are backed by the financial strength and claims-paying abilities of the issuing carrier. This podcast is intended for informational purposes only. It is not intended to be used as the sole basis for financial decisions, nor should it be construed as advice designed to meet the particular needs of an individual's situation. LaBarge Financial is not permitted to offer, and no statement made during this show shall constitute tax or legal advice. Our firm is not affiliated with or endorsed by the U.S. government or any governmental agency. The information and opinions contained herein, provided by third parties, have been obtained from sources believed to be reliable, but accuracy and completeness cannot be guaranteed by LaBarge Financial. Kaitlyn Johnson and Liberty Legacy Law Group are not affiliated with LaBarge Financial, AEWM, or MAS. LaBarge Financial has a strategic partnership with Kaitlyn Johnson of Liberty Legacy Law Group that can provide legal advice. Kaitlyn Johnson, Liberty Legacy Law Group, and LaBarge Financial work on a referral basis and do not exchange compensation. Liberty Legacy Law Group, LaBarge Financial, Madison Avenue Securities. MAS, member FINRA SIPC, and AE Wealth Management, AEWM, a registered investment advisor, are not affiliated entities. Any and all other services offered by the strategic partner are not offered through or supervised by MAS or AEWM.